Okay. Well, welcome. My name is Mark Irvings. I've been involved with the Lenny Zakim Fund for 20 some odd years. I'm currently on the board and the co-chair of the Community Investment Committee, which does the grant making and the educational programs. In my work life, I am a mediator and arbitrator of employment disputes dealing with every conceivable workplace in New England, actually nationally. So April, please introduce yourself.
Sure. Hi, everyone. My name is April Wallace. I am the Executive Vice President of Human Resources and Administration with the Greater Boston Food Bank. I just joined as a board member, very privileged to do so with the Lenny Zakim Fund. I can't believe it will be a year in December, but still feel very new and learning a lot in my professional life. Otherwise, I've been with the Greater Boston Food Bank for just over 7 years, and then also have been in human resources for a long time. So very happy to be here.
Great. So the genesis of this program was the realization that the Zakim Fund supports and interacts with many small organizations, most of which can't afford to have a full-time human resources presence, and that it's really important that the organizations understand some basic employment law issues and obligations to avoid problems. So we started this. This is designed to help you folks. So at anywhere along the line you have questions, please raise your hand or put something in the chat. We don't have to wait till the end, and you don't have to remember it. We'll deal with it as they come up. We're going to start with the topic of the classification of people in your organizations. Employees, volunteers, interns, because this can have it's crucially important, particularly in Massachusetts, for reasons I'll go through. We'll then go through the hiring process, what you can ask, what a permissible basis for declining to employ. Then we'll deal with what requirements you have. Well, you'll also deal with things like your issues around Corey, about what you can check, what you can't check. We'll talk about record-keeping requirements and the applicability of the broad array of employment laws, both federal and state. And then we'll touch on managing employees, evaluating, disciplining, terminating, if necessary. So that's going to be the flow of the program. And again, please, as we go along, if you have questions, please ask them. So employee classification, very hot topic, both nationally, but particularly in Massachusetts. And by classification, I'm talking about, are you treating people as employees versus independent contractors versus and volunteers or interns? And you have to get this right. And I'll tell you a brief anecdote from a case that I mediated. Small organization, wonderful, started by 2 women doing training, empowerment training for women, and they would teach classes. And these people were treated as employees. This organization had a board member who was a lawyer from a big firm, but a corporate lawyer. And this corporate lawyer said to them, you know, you could save a lot of money if you treated these people, if you called them independent contractors, then you wouldn't have to pay payroll taxes or benefits or anything else. So all of a sudden, people got converted to independent contractors, 1099. Well, at some point, one of the long-term people got terminated, and she went to a lawyer and said, this must be illegal. This is so unfair. And the lawyer said, well, unfair is not illegal, so there's really nothing we can do. But let me see your pay stub, which is what employment lawyers do. And the employment lawyer looked and said, wait a minute, they're treating you as an independent contractor. you really should be an employee. And so they brought suit. Now, if you get it wrong, and you've treated someone as an independent contractor, you can be subject to, and you haven't paid proper minimum wage, or you've taken improper deductions, the variety of remedies, but it's treble damages and attorney's fees. And this organization that $100,000 budget got hit with a $75,000 settlement. And this was because someone who was operating outside their area of expertise gave advice, and it was bad advice. In Massachusetts, there's a statute, Chapter 149, Section 148B, that establishes the criteria for who is an employee versus who is a independent contractor. And it's a three-part test, which I had and cannot find right at the moment, but it basically, does the person, are they operating without direct guidance? Do you bring somebody in, for example, you bring in an electrician to wire your offices, they're not asking you how to do it. They know what tools to use, the process. But if you have someone who's in your office and they're getting instruction from you, do this, do that, you're supervising them, then they are not free of your control. The second test, which is really important, is, are they performing the services of your organization? And this is what has captured these cases, whether it's delivery drivers, whether it's teachers, whether it's, exotic dancers, the whole range of people who work in Massachusetts. If they're doing what your organization is doing, they're employees. So that's the key one. There is a third test, but essentially, do these people have their own business effectively? Are they doing the same thing for multiple places? For example, you hire a grant writer who's writing grants for you and for 7 other organizations. That's okay. That can be an independent contractor. But if the person is just working for you full-time, you can't call them an independent contractor. They are an employee. And you can hire temporary employees. You can hire people for a limited amount of time or a project. You can hire people part-time, and you can set different compensation rates and benefits for different categories of employees. But please don't call the people who are doing the work of your organization independent contractors. So, volunteers, which many of you organizations use, and not-for-profit, as opposed to a for-profit enterprise, a not-for-profit enterprise can have volunteers, but there is still, you got to look at the total picture. If they are not supposed to be displacing your employees, if they're in addition to your employees, that's fine. You can provide you can, first of all, reimburse them for any expenses. You can provide some stipend if you want, but it's got to be very limited. I believe the rule is no more than 20% of what the pay would be for an employee doing similar work. We've been asked by people, well, we get a student in and we give them $500 for the summer. That's not a problem. But if there's an expectation that it's going to lead to employment, if it's, you say, we're going to have a volunteer, but for the first 3 months you volunteer and then we'll hire you, no good. Because that's really somewhat effectively a probationary employee. But if you're truly having people come in, and whether you send them out to tutor somebody or things like that, that's okay. Do people, since a bunch of you have volunteers, are there any specific questions that you have about the use of volunteers? let's see.
We have one person who asked about liability. And
Yes,
then,
okay, director and officers errors and omissions. Typically, it will not cover contract claims. It will, I mean, and it is actually a very important question because there is under the Wage Act, the Mass Wage Act, personal liability for the head of the organization and the person in charge of financial things. So it's really important that you get this right. That you don't get all of a sudden here, you're doing really important work and you're trying to do your best, and a disgruntled person brings a suit and your organization doesn't have any money and someone looks at you. So it's important to get this right. And you've got to look at your D&O policy to see what exclusions, because they typically will not cover the damage on a wage and hour claim, because the insurance companies don't want to be in the position of paying because you decided to try and save money and misclassify an employee. Other questions about that? Okay. Related to that, employer's obligation in terms of timekeeping. The issue is, and this can come up with overtime. If you're supposed to keep accurate time records, it's the employer's obligation. If the employer doesn't keep accurate time records, then if a person brings a claim, the courts will allow them, the employee, to give a reasonable estimate. And in all my years of doing this, I have never seen a claimant underestimate how many hours that they worked in a week. So it's really important that for your non-exempt employees, non-exempt, counterintuitive term, non-exempt means you're entitled to overtime. And I won't go through the morass of the difference of exempt and non-exempt. If you have a question, we can deal with it privately because it's very complex, but basically non-professionals are non-exempt, and they're entitled to overtime. So you've got to have accurate time records. And it's not going to be a defense to say, well, I never authorized specifically the overtime to be worked. If an employer suffers people to work, meaning you didn't stop people from working, then you're responsible for paying for it. Okay, so this is important that you have, it doesn't have to be a time clock. You know, it just some orderly way of keeping track of the time of non-exempt employees. Okay, yeah, any questions?
There's a question in the chat. Someone asked, if someone regularly cleans the space, is that a contractor or a W-2 employee?
Typically, if they have their own cleaning business, then it's a contractor. If they're cleaning your space and 7 other offices, that's an independent contractor. If they're just cleaning your space, even on a part-time basis, and if you're providing the cleaning supplies, they're not bringing in their vacuum, they're not bringing in their mops and the other stuff, then it's an employee. I have a person clean our house 4 hours a week. I pay payroll taxes. I pay all the mass paid leave stuff. I pay unemployment. So the key is, if the person has their own business, they're a contractor. If they're just coming in and they're using your vacuum and your mop and the rest, then they're effectively either a full or a part-time employee. Good question. Others? Question, if they contract to work a certain amount of hours and they choose to work more, yes, you owe them for that time. So, yeah. Again, good question. You either tell them this is how much we're willing to pay for. They can't volunteer for additional hours because the policy behind it is that if employers could have people volunteer to do additional hours in their job, people would be coerced. It's not really voluntary. They would be under pressure. And many employers would say, oh, no, they agreed to work, be paid for 10 hours, but to work for 30 more on a volunteer basis. Not good. You've got to either control what they do. You got to tell them, thanks, but we can't afford that additional time, or you pay them for it.
Someone asked, do you have to give a reason for firing an employee?
We'll get to the whole discharge. Let's hold that question. We will definitely deal with it later. But let's turn for the moment. April, you want to take them through the hiring process?
Oh, the hiring process. So thank you, Mark. Everyone, you'll see me continuing to nod because this is what I live for in day to day. So the hiring process, as we all know and probably have experiences, continues to get more complicated. And with all of the complexities of the employment laws in Massachusetts, it's always hard to figure out what you can and cannot do and what you should and should not do. So I start this part off more so to say that none of us always have the answers. Not everybody has all of the answers. It's really important for you to have resources at your disposal to be able to contact someone. Most organizations do not have as part of their financial resources what they can do for employment attorneys, but there's tons of information online. I can share resources. You also have Mark and I and other members and our network as well. So I strongly encourage you to utilize the resources that you have, because this will not be an exhaustive list by any means. When you are considering hiring for positions, the complexities begin from the very moment that you decide what the role is. And what I mean by that is you may understand what you need, but communicating what you need in a way that does not cross any lines from a discrimination standpoint are really important. And so you want to think about what is a need versus a want. And in articulating what the needs are, you have to think about what skills are required versus preferred to execute on those skills. So is a degree really required? Is a high school diploma really required? How do they use those learnings and what they're doing? Do you need someone who will be available for certain times during the day or on the weekends? And you have to be able to articulate that. One of the things that I have found that comes up if you don't articulate what true needs are versus preferences, then you can exclude people from a discriminatory standpoint and not even realize that you're doing it. So I always say that it's not about when you get to the interviews, it's when you are beginning to think about recruitment. And quite frankly, this also can apply to volunteers as well. If you're thinking about what the need is, you want to think about what you're looking for. There are some organizations that need very specific types of volunteers. And so you want to think about that. Then when you are considering candidates, you want to again refer to what are the requirements as opposed to the preferred, and use that as a guide. Now, a job description may seem a little bit formal, especially if you have 2 employees or 2 positions or 200, but they really can help ground you in what you should think about and remind you of the needs versus the preferences. So even if you have the job posting that you have that may be a little less formal than a job description. It will help you to do that and have really critical conversations with candidates. So once you identify candidates based on the skill sets required and what your true needs are, and you're at the interviewing stage, interviewing is another area where it causes employers to get in trouble, quite frankly, before they're even hiring anyone. So the things that Mark talked about thus far are topics that are once you have somebody already working, but you can make critical errors very easily when you are interviewing. And so there are questions that you should stay away from. And when I transfer the virtual microphone back to Mark, I'll put some things in the chat so that there's some resources, some links that you can use too. But there are some basic questions, questions about how old someone is, what year they graduated high school, and at this point, college. If you're like me, I can't believe that I graduated college as many years ago as I did. And so nowadays, if you put the year of that you obtained your college degree, that could be challenging. So I usually advise folks to not ask the years of any degrees. If it's not on someone's resume, not to ask about it. You want to avoid asking about their family life, right? Are you married? Do you have a partner? Do you have children? Do you plan to have children or get married? One could argue that is none of your business when it comes to my professional life. But more importantly, you don't want to, if you ask a person these questions and then you do not hire them, it could open them to think that how they answered those questions or why they were not hired. And that's where employers or potential employers get in trouble in asking questions. Now, one of the questions that I always get is from supervisors is, well, how can I find out if the person will be able to do the job for 40 hours a week? Well, first of all, you start with the job description and say, and you put in there, this is a 40-hour-a-week job that requires you to work Tuesday through Saturday. If you put that out there as a job requirement, then you only have to ask, are you able to work the hours and the schedule that was described in the job description or in the job posting? Or you can start off by saying, if you don't have those two, then you can start off by saying, the schedule that we need you to work are Wednesdays and Saturday evenings from 7 p.m. to midnight. Are you able to work those hours? Yes or no question. You don't have to ask why. Sometimes candidates will elaborate, but you can find a way to say, thank you for sharing, thank you for responding to the question, not pick up on anything that they elaborate on, including, oh no, I have to take care of my aging parent. Thank you for responding to the question, and then move on. I know some of these things are hard because you want to be cordial during a conversation with a candidate, right? Especially if you think that they're going to be working for your organization, but you want to make sure that you avoid those personal questions. Are you planning to get pregnant? Yes, that is still asked, unfortunately. If you're looking for trouble, that will definitely get you there. You know, what is your gender identity, right? Now, in this world that we live in, what we have transitioned to at the Greater Boston Food Bank to show that we are an inclusive organization, or to demonstrate that with candidates. And Indeed.com has a very great commercial on this. It's, you know, I introduce myself as the recruiter. I say, my name is April Wallace, and I use the pronouns she, hers. Are there any pronouns that I should use for you? There you go. Right? And so it's not saying, what do you identify as? It says, these are my pronouns. Are there any that you would like me to use for you? It may seem like it skirts the line. It's not the what necessarily, it's the how you ask. Is English your first language? That shouldn't matter. What should matter is, can someone communicate and comprehend in English, if that is a requirement for the job? right? Now, if you're trying to understand whether someone can speak another language, again, in the job description of the posting, you can put Spanish speaking a plus. And then you can ask, do you speak another language? But not, is English your first language? You want to stay away from questions about religion. Unless, and this is still difficult. I know that for, say, religious organizations that also have private schools. So for example, my son went to a private school, a private Catholic institution. And what we find is that with some institutions, it is a requirement for very objective reasons to be someone who is practicing of that faith. But that needs to be clearly laid out in a way that connects an organization's mission to that religion or that religious practice and be laid out ahead of time, right? And so you still want to be careful in asking questions. It's really about, can you meet these requirements, not just this requirement, but these requirements, or asking a question about, will your religion conflict with working here on Sundays? No, it's about the schedule. Asking about anything that has to, we're in election time. And sometimes people want to think it's good to chit chat about what's happening in the political environment. I think that's challenging as an employer and an employee relationship just in general, but definitely avoid questions like that. Asking people if they've ever had workplace accidents or being sick in the last several years, if they have financial debt. You should remove any of those questions from your toolbox. One in particular that comes to mind also in Massachusetts as it relates to Corey that Mark just asked is you cannot ask about if someone has been arrested or been in trouble legally. If you perform not performance reviews, forgive me, we're in performance review season right now. If you perform background checks, that will come out. What you can say is you can talk about your recruitment process, and you can say our recruitment process includes background checks and drug screenings once we extend an offer to a candidate. You don't have to ask a question. You don't want a response necessarily. You just want to inform what the process is. We do reference checks in addition. And so for the most part, anyone who has some concerns about that will, at a minimum, express them or after the fact, or they may just withdraw from consideration. So those are some of the things that you want to stay away from. I'm happy to answer any questions. I do see one in the chat. Do these anti-discrimination practices apply to volunteer recruitment and interviews too? So how I will answer that is they may not technically, legally by law, be considered discriminatory. However, I would strongly recommend that you follow these, not mine, I'm just sharing based on my expertise, but I would say adopt similar rules to engaging with volunteers as you do with employees for a couple of reasons. One, Mark shared an experience that there was a volunteer who was then determined to be an employee. So there's that part. And then the other thing is just think about what kind of environment you want for your volunteers as well. So if you want to demonstrate that you are just as much as an inclusive environment for everybody, whether they're an employee or a volunteer, using these as a guideline would probably be helpful. So hopefully that answers your question.
If I might, it also would protect you. I mean, it's good muscle memory within the organization that you follow a uniform approach. But if someone who is covered, clearly an employee, brings an action against you saying, or someone who wasn't hired, and they say, well, I wasn't hired because they heard I had a disability or they asked, and it turns out that it's something that you ask of volunteers, then it lends credibility to their claim that you asked them. One other thing I want to say in terms of questions you can ask now in Massachusetts, you cannot ask what their prior salary was. Okay, very important. The rationale for this is that it's a question that has been used to effectively hold down women's salaries because once they start low, if you say, well, I'm paying you more than you got before, but it turns out that the men are all being paid more, it was the way companies had very disparate pay scales. So it's now unlawful in Massachusetts. You can say what your pay scale is, but you can't ask somebody during the interview process. Or I guess even after you decide to hire them, if you're negotiating what the salary is going to be, you can't start it by saying, well, what did you earn at the other place?
That's true, Mark. I will just add, because sometimes you want to get an idea of whether you are on the same page in general. So you share what your range is. Also, one question that we use is what are your minimum salary requirements?
Yes.
That's not asking them what they've been paid. We all, and first of all, we all want to be paid more, right? So my minimum salary may not be what I expect to be paid, right? So asking what their minimum salary requirements are, and you may get someone that's very skilled and says, well, what are you offering? And you share that, and you also can. I think it's important to be candid around compensation, and if someone shares something, it's like, okay, that's good to know. I just want to be candid with you to share that our range is XYZ. So it's really critically important, but you can ask what their minimum salary requirements are.
It's an interesting phenomenon now. I've been reading things in terms of when the job market was hot, and despite the Fed's efforts to tamp down the economy, I'm told it's still very hard to hire people, but that they're finding that applicants will only apply to jobs where the salary range is stated. But so you're better off also in terms of how you spend your time. You don't want to have people applying, and then when they find out what you're paying, they say, well, I'd never work for that. So just in terms of recruitment, putting out there what it is you can pay makes some sense. Okay. You want to talk about record keeping requirements in Massachusetts, April?
Record keep everything. I say that because as I find between Massachusetts and California and New York, the list keeps getting longer. And so this is, again, we have a few minutes together. What I will share with you is really at a high level, and happy to talk through more. But there are rules around, most of the time it's 7 years. 7 years. There are rules around anything to do with employment. Well, let's start with compensation. Anything to do with compensation, payroll records, offer letters. Sometimes, if you have, in some companies, you may not be as sort of complex as this, but if anything around how you may pay merit or bonuses, or why certain people received increases and certain different, you pretty much have to keep all of that information. You don't have to keep it actively at your fingertips, but if you have a certain place that it is stored, you need to make sure that it is stored in a place that you can retrieve it, that it will be protected. Storing electronically is perfectly fine, but I would just tell you, password protecting that and only limiting access to those who absolutely need to have it. Thank you, Mark, for putting that in there about personnel files. Anything related to that. You also to being paid. And so if you have, so working with accounting and finance, or you may be accounting and finance, right? So you're not only what people were paid, but your paycheck records. So some organization like ours, we have, we work with an ADP or some larger sort of system. So for us, it's all intertwined, but whatever your pay records are based on your paychecks. So your banking, you want to make sure that you have those. And there are rules on that side of the fence as well as what you need to keep. Performance evaluations, you want to, and I don't know how many of your organizations are conducting those, but whether they're super formal or just the documentation of a conversation about good and not so good performance, you want to keep that with the employee records as well. And the reason why that is it ties into a little bit about compensation. If you give someone an increase and you don't give another person an increase, or you give someone a higher increase and you don't give enough than someone else, then you want to make sure that you have the documentation. Particularly if you let someone go, you want to make sure that you have the documentation that you did that. The other thing that is important to keep is information, and I'm going to say this and then sound like I'm talking out of both sides of my mouth. You may find that you have to keep information about health. And I say may because depending upon how many years, depending upon how many employees you have in your organization, you may be subject to state and federal leaves. And if you are, then you may be on the receiving end of personal health information, right? And so you have to keep that information. So you may have to keep it for leave law compliance, but you have to keep that separately than an employee file. So as an example, here at the Greater Boston Food Bank and most organizations, we have 2 sets of files for every team member. We have what's contained in an employment file that is, things that I talked about, their new hire paper, it could be new hire paperwork, offer letters, performance evaluations, those sorts of things, information about their compensation. And then we have personal protected information that is of a health status. So any doctor's notes that we've received that are important for us to hold on to through the length of a leave. If someone was eligible for a leave of absence under the Mass Paid Family Leave Act or under the Family Medical Leave Act, or any other thing that they might be eligible for. If there was a workers' compensation claim, you'll receive information about their health that way. That should be separate. It is a separate file, but it is not part of the employee file. Because what happens is just so that you know, as an employer, employee records can be accessed by employees. If goodness forbid you have to do litigation, there are some things that should not be in an employee file that you give to an employee, an attorney versus not, and it's the protected health information. In order to share that protected health information, an employee would need to give, a release. Would need to release and authorize you to give that information to someone else that you are otherwise not legally obligated to do so. This is, there are certain minimum requirements in terms of number of employees. And so there may be some of these things that do not apply legally to members of this, the tiles here, but it is still good practice. The other thing that I will say is one of the laws in Massachusetts that's recent years, not recent like this year, but recent years, is what is considered an employee document. And where employers get in trouble is supervisors will hold on to notes about an employee's performance and not share it, not included as part of their employee file. And there's actually a law that says anything that relates to performance needs to be part of the employee record. So before this law came into effect a few years ago, or maybe it's 10 now, it's been a long time, is just human, you would be a supervisor, you would keep it in your, or keep note of it in your, in an Excel spreadsheet or something, but the employee would never be aware, because this is something that you are doing so that you don't forget things, or you would use it so that if you're doing a performance evaluation later on, 6 months from now, you would have the notes. The difficulty is that particularly if there's an employment action that results in someone leaving an organization, being let go, the reference to, oh, well, we have this documentation, or these are all the things that led to this separation, but the employee was not aware of it. That's where employers get into trouble. So I would recommend that even if you're not legally required to follow all of these rules that you just want to think about where are all your where's all the documentation located that you have on employees, whether they're current or not. What is your you retain the information, but then also you can shred and throw out information. So what is your practice in doing that? Who can have access to employee records? Because not everybody should, right? And so just because someone is a supervisor doesn't mean that they should have full access to an employee file, because there's a lot of personal information, name, date of birth, family information that a supervisor doesn't need to know. So who has access? And then also for those who have access to personal information, name, addresses, telephone numbers, social security numbers, anything like that, there should be training of how to keep that information protected. And there is, and Mark, I'm experiencing a brain freeze here, but there is HIPAA. There are HIPAA requirements and Massachusetts actually several years ago had instituted more stringent laws than the federal laws regarding how you protect personal information. So there's something around personal information and personal health information. And so anything that personally identifies someone, driver's license information, and this can apply to volunteers as well, driver's license information, home address, social security, combined with their name in any way is personal identifiable information that needs to be protected. So if you get any of that information for volunteers, you should have or develop a program that protects their information as well. And then depending upon how many employees you have, if you have a data breach, you may be required by Massachusetts law to disclose that, and there are certain requirements around how to disclose that and within what time frame and all of that. If any of you have ever had your credit cards or your personal information, you may have received something from Target or for any of these places. It's something similar to that, not as robust, but there are certain obligations in Massachusetts as an employer.
Let me just add in, and people should really read the chapter 149, section 52C, which governs personnel records. But a particular call to the attention, because it's apropos to what April said about little notes that people write. It is required that an employer notify an employee within 10 days of the employer placing in the employee's personnel file any information to the extent the information has been used or may be used to negatively affect the employee's qualification for employment, promotion, etc. So if you write up a memo, which is a good idea, it's important to document. And we'll get to performance issues, but it's important to actually document things. If you document it and put it in the file, you're obligated. You're obligated to tell the employee of it, and the employee has the right to put in a response. If you have stuff in the file that you've never notified them about, and then you do some action, you make reference to it, you have some substantial exposure there for having violated the public records law. So I know it's a hassle. Employers hate this, but it's a good practice. The last thing you want to have is to take an action and have the person said, this is the first I'm hearing about any of this. Why wasn't I told? Why is this in my file and why are you using it? So
yeah, Mark, if I may, and then there's a question. I will also add that there are depending upon the types of records you have related to employees, there are different amounts of time that you are required to keep those records. So I just, as a matter of practice, tend to keep records for the maximum time based on the whole collective, because it just makes it easier. But even down to if I-9 forms, which are the immigration forms for when you hire folks, you have to have some way of holding on to those and then shredding those. So what is your what is your practice in getting rid of records, particularly records that have to do with a person that have personal information. You should be shredding them and have a document that speaks to, do you use a shredding company? Do you have something on site? Something like that. Then there's a question about, does it count as a check record? Oh, sorry. Does it count as a check record, the bank statements which show the checks people deposited? If the question is about proof of paying someone, then I would say yes, because you want to make, if that's the only way to show that the check was actually given to someone and then cashed, then yes, I would say that you want to keep that in case someone ever claims that they were not paid for certain hours. It's really, the other thing that I would suggest, even for smaller companies, if you have 1 or 2 employees, is what is your record keeping as it relates to hours worked? You don't need a fancy system. Excel works just fine. What you can do is just put Monday, Tuesday, Wednesday, Thursday, Friday, you put it in there, you make sure people have their lunch in there, and then someone needs to sign it. You can do an electronic signature, but then save it as a PDF so that it can't be changed at any point, right? Because checks don't all, if you just are writing still hand checks or sending it electronically, they're not going to talk about the hours worked, right? They're just going to have an amount. And so you just want to make sure that you're capturing the hours work that led to the calculation of the paycheck, if that makes sense.
Okay. Applicability of different statutes. There are in Massachusetts, well, federally and Massachusetts, just a blizzard of different laws. And rather than going through each one, I included in the chat a link to what I thought was a very good summary. Well, it goes on for 10 pages, so it's not that much of a summary, but it takes each law and says what's applicable or what is not, depending on the size of the workforce. A lot of the laws in Massachusetts start at 6 employees. So a lot of them may not be applicable, but it may also be good practice to be aware of them. And I'm talking about things like the paid leave and all the variations of that. If there are specific questions on which laws are applicable, maybe you can ask them, but otherwise, use that as a reference. And if you have questions, feel free. Yep.
Julie was just asking, I asked one of
Go ahead.
but Julie was asking a question about what does employment at will mean? What is employment at will and what does it mean in the state of Massachusetts? And I am chuckling ever so slightly because what it means and how it's applied in Massachusetts, I find as an employer are 2 completely different things. There's a little bit of bias there. So employment at will technically means that an employer, unless there's a contract that states to the other to the opposite or otherwise, an employer can separate from an employee or terminate an employee's employment for any reason. So unless there's a union contract, an agreement, or some sort of contract between the employer and the employee, you can let someone go for any reason, except you really can't, right? At a minimum, anti-discrimination and anti-harassment laws, any separations that are steeped in that or even connected, that would not be something you should do. Where this really comes in is, oftentimes employers are letting people go because they didn't follow the rules or they're just not performing. And so while you can still certainly separate employees, and you want to do what's in the best interest of your employee, of your organization, those that you serve, your culture, you want to make sure that there's lots of documentation, because what will happen is someone most often is not in agreement about being let go, the reasons why, whether they should have been and or the reasons why, and it'll be the employer's responsibility to show why it was something that the person should have been let go for, right? At a minimum, this comes up in unemployment. So what most people don't understand, most employees, regardless of your position in an organization, is that the state makes the decisions on who gets unemployment and who does not. So even if you let someone go for what you think are reasonable and objective reasons, the state asks you for information, you share the information, and then they make a determination based upon the law and the information that's provided. And so you may let someone go because they're at will and feel that you don't need to even come up with a reason. But in actual application, you should always have a reason. It should always be objective, and you should always have documentation that supports the objective reasoning for letting someone go. So that's why I chuckled, and that's also, and this is from an employer perspective, right? Because I'm not an attorney, but then also I know that Mark is a mediator, so I'll defer to, give the microphone to him, but just to start answering the question that Julie posed.
Okay, thanks, April. Good segue. Just so we're clear, you can let someone go for any reason unless it's unlawful. And it's not just the discrimination laws. If a person has complained or raised questions about their pay rate and you let them go, that's retaliation for exercising a protected right. Very important. What may happen is, and employers will say this happens all the time, a person knows they're in trouble, and so they come in and say, well, I don't think you're paying me correctly. And then they get, the termination you had planned on now gets judged against, well, is there some documentation that shows that you're going to be terminating that person? And they got wind of it, so they started, throwing up protective screens. So it is, as April said, very important that there be documentation. There is no legal requirement that you conduct evaluations. It may be good human resource practice to conduct regular evaluations, but what I will say, what's vital is if you're going to have any evaluation, it's got to be candid. It's very hard to give difficult evaluations saying, look, you're not doing this. This is what we need you to be doing. And so often, I mean, the number of times I had cases, teachers, it came time for layoffs and they laid off this person and they said, well, it's because they weren't performing. And the person says, well, wait a minute. I have 25 years of exceeds expectation evaluation. And they said, well, yeah, but we really knew you weren't doing the job. Then it becomes evidence of pretext, so that you didn't really do it because of performance. You did it for some gender, race, sexual orientation, whatever it is, it becomes a pretext. So as hard as it is to say difficult things to people, you've got to do it. If they're not performing, you've got to lay it out. This is what the expectation is. This is why we're not satisfied with what you're doing. You're not required to give progressive discipline. I think it's good personnel policy, meaning, look, we're serious about this. If you don't straighten this out in 15 days, in 30 days, whatever, we're going to you're going to be suspended or we're going to let you go, but you're not required to do it. Be careful, and we can get into handbooks a little bit, but be careful what you put in your handbook. Glowing aspirational language in your handbook can come back to bite you in the ass. Don't have, we treat everybody fairly. We discuss with them. They're all part of our family and this stuff. Well, when you have a difficult employee and you want to let them go and they say, well, but you didn't take me on a staff retreat and we didn't have, therapeutic counseling. And geez, you seem to indicate that all of that is part of our ethos as an employer. If you have all that stuff in your handbook, you're going to be held to it. And it can actually, despite it saying you're an employee at will, it can create a contractual basis for employment or for procedural steps that didn't get taken. So be careful what's in there. And if you, as I said, if you're going to document, make sure you do it correctly. If you're going to let somebody go, be honest about why you're letting them go. If you say, well, we don't have the funding for this position, and so we've got to lay you off. You're really wonderful. We love you, but we've got to lay you off. And then 2 weeks later, you've posted for the position and you hire somebody. And you say, well, we didn't want to offend them. We didn't want to have a termination on their record. They then come back and say, well, clearly it was pretext. You weren't laying me off because you couldn't afford the job or the duties no longer existed. You laid me off for some unlawful reason. So if it's performance, you can say to someone, it's for performance. You can say to them, look, we're going to have to terminate you. If you would like to resign, that's fine. We can do that. And you can decide whether there's some severance or whatever. But if you're terminating them for a performance reason, don't pretend it's something else. Life goes on, but you've got to, the worst thing you can do is to be less than candid in what you say to people and what you document. If you have a matter of poor performance or misconduct, the process you want to follow, even for egregious misconduct, you want to make sure that you are investigating fully before reaching a conclusion and taking action. Impressions can be wrong. Also, if you're directly involved in what the person did, you may not be as objective as you think. And there's never a rush, even for the worst possible offense. The notion of, a person did something, you're fired, get out of here. Real bad. What you can say to someone is, you've got to leave pending, you're suspended pending investigation. And you take a step back and you decide who needs to investigate. If you have a board, you may want to run this by your board, but you want to be really careful, particularly if you're personally involved, that you get some other perspective. One of the things that you can get in trouble with, you terminate somebody. When you terminate, you have to give them a check that day of all their accrued wages and vacation. Chances are, if you fire someone out the door, you haven't got that prepared. And if you fire them and they then run and make a claim for unpaid wages, even if you subsequently say, oh, you're right, here's everything that you're owed, you've now violated the Wage Act, treble damages, and attorney's fees. In recent court decision, Mass Supreme Judicial Court decision, even if you paid before they filed suit, you're still subject to the treble damages. So there is no rush in actually implementing a termination. You can get the person out of the workplace if need be, but don't say you're fired. Okay, really important. I also think it's very important that somebody, a decision maker, interview the employee before you make the decision. If you do it based on what someone else said the person did, I can't tell you how many times in my 40 some odd years of hearing these cases, it turns out it's more complicated than it first seemed. And if you've made the decision before speaking to the employee, giving the person a chance to tell their side of the story, produce other witnesses, whatever, you can too often make a bad decision. And then you're trying to defend a decision. And it's incredible how recollections change to conform to the decision that was already made. So it leads to bad decisions. So I can only urge you to take your time and be careful and make sure if it's a performance, a long-term performance thing, that you have documented along the way. And, you know, it is possible if it's an employee at will, that if you didn't document, you can fire for bad reasons. You can be incredibly unfair. You can be arbitrary. Legally, you're still protected, but it creates the impression that you've done something for improper reasons. And that's really something, the cost of getting involved in one of these disputes is enormous. It can be bigger. I mean, knowing the organizations that the ZACM Fund supports, the cost of one of these cases, just the transaction cost, can be greater than your total budget. And chances are many of you don't have employee practices liability insurance because you're a small organization, but the attorney's fees can quickly exceed everything, 5 years of your budgets. So be prudent. It doesn't mean you have to tolerate poor employees, but you need to be measured in your approach. April, do we have any questions? You want to chime in? Because you've had a lot more experience implementing it than I.
Yeah, I have been answering some questions in the chat. But there are two questions I haven't gotten to yet, and I really appreciate all of the questions. So this is great. So if an employee is let go and they launch a public campaign against the employer, what is the employer legally able to publicly disclose to defend themselves? Again, I am not an attorney. I just sometimes play one on television. But what I will say is that employers in general are not allowed to disclose anything as it relates to an employment matter to the public. And so I do, especially working for the Greater Boston Food Bank, appreciate that in a way something like this is tarnishing the brand and therefore maybe may impact the ability to attract and retain donors, as an example, or attract and retain volunteers. But you really need to tread lightly with when you're considering defending. Sometimes I have found the best defense is to not defend. But if you think that you really need is to not to do it publicly, because you don't want to get in this tit for tat and then end up making it worse for yourself. But the other thing is that if you are considering doing something publicly, to the extent that you're able to lean on resources for low or no cost and how to navigate this for the organization, that's what I would advise, is to touch base with an attorney or someone that could maybe help with this, someone in public relations. And just, there's one of the recruiting, Glassdoor is always just a really easy way for people to get in a tit for tat about responding to things that people complain about. So I would just caution and really about thinking about whether it makes sense to try to defend in the public, especially with social media. But definitely, not saying anything about the person and disclosing anything about an employment matter is pretty important, despite what the public may want. I'm just thinking about what's happening with the Boston Celtics right now, and it's a really interesting study in employee relations and what's happening with them, with who's going to be the former head coach. So just a thought there. Olga asked, how do we pay someone in advance on the day of firing if working by hours and they submit to them in order to get paid? That is an excellent question. So in theory, we should know what people are working and how many hours. There is a best practice in that if you're not sure if the person, how many hours the person worked in that day, then just pay them the whole day. Now, I recognize I'm saying that, and I work for a larger not-for-profit organization, but I have practiced that since I was learning about human resources. It helps you to meet the compliance of it. Now, the other thing that I will say in this hybrid, these bifurcated cultures where you may not even see the person, is that to give them the check, is that there's been, I would say, a slight interpretation in that if they're not right there, then you overnight it. Right. So I know, especially in these times, it's like, how do I physically give someone something if they're not on site or anything like that? And so it happens to the best or the worst of us. It's also about the attempt as well. So if you send something that you have to overnight, get it tracked so that you can have proof that you did comply with the law. So that's Olga. That's scary, but thanks for sharing. Let's see. I don't see any other questions if I missed, so I will pause there.
Okay, references. You've terminated someone and they say, can I have a reference? The pretty much standard practice now in the employer community is to say our policy is to confirm dates of employment and positions held. Now, for your perspective as hiring employers, that's really frustrating because you can't find out that unless it hits the public media, unless it's in social media, you can't find out about other people's real prior performance. But as an employer letting somebody go, it protects you, because the danger is if you start giving references, then a person brings a suit about defamation because they say, oh, I didn't get the job because you badmouthed me. And you're in a vulnerable position. If you are going to give a reference, maybe it's, it wasn't misconduct. It's just, this wasn't a great fit. The person did 3 things great, but you needed the 4th thing was the key. If you are going to give a reference, it can be an agreed upon written run. And if someone then calls, you say, well, our policy only allows us to have the written reference, and that's all I'm permitted under our enterprise policy to say. But it's protective for you if you're letting somebody go. Okay. April, you want to talk a little bit about employee handbooks in the time we have left?
Employee handbooks, they can be your best friend in most cases. Sometimes your frenemy, but in most cases, your best friend. And they don't have to be 1,000 pages. They can be 5 pages or anywhere in between. But if at a minimum, they help to communicate the expectations in terms of working for an organization, right? So what are the differences in employee status? So if you have full-time or part-time, right? You do have to tell people when they're going to get paid. An employee handbook will serve for that. So if you get paid, if you're paying bi-weekly on a Friday, you need to tell that. Now, that can also be handled by some of these employment law signs, but if you're going to have an employee handbook, throw it in there. So when you're going to get paid, how people are going to get paid. So for example, we require everyone to have direct deposit. So if you make that a requirement or something like that, then you want to do that. Any information about benefits, it doesn't have to be super detailed. What I mean by that is it doesn't have to be the entire summary plan. If you offer benefits, it doesn't have to be the entire summary plan description for a Blue Cross Blue Shield HMO. No, but you can talk about in general what full-time employees get for benefits and what part-time employees get or don't get, because it could be different and oftentimes it is. And then you can always say, please refer to the summary plan description documents provided by Blue Cross Blue Shield, and right. You also want to talk about in terms of the classification, if you give any vacation, paid time off, who's eligible for that, who's not eligible for that. Paid sick in Massachusetts, paid sick time leave is in there. So you put those things. If you're required to comply with any leave practices or leave laws, you want to put that in there. Let's see, what else do we have? Mark, it's funny. He mentioned things about values. Or that we're a family. I will say we have our values in our handbook. And the reason why that is there is because those help us set the culture. And where that becomes important is if someone is not, as we call it, living the values, and their behavior is counter to the culture that we want, it may not be a legal compliance, someone was harassing someone, but it is very possible that they are doing things that are counter to the culture that we want, being a bully or something like that, that we're going to let someone go. So I will say, while I totally agree about we're a family. First of all, family and work is even if you're working with your family, is usually complicated, but we're not a family, we're a business, and we have a culture we want, and there are values. So we have our values in there as well. We also have, what also might be important for you to talk about is, or to mention in there, are expectations in terms of work schedules, sometimes depending upon, so our core business hours are 8 a.m. to 4:30 p.m. So we expect in general for team Monday through Friday. So in general, we share that so that those expectations are documented in that way. Now, of course, we have a warehouse, so some of them come in earlier, but in general, we put that in there so that people know that everybody, for the most part, unless you're part-time, are expected to work at, an 8-hour day, if you will. Just forgive me, I'm looking at my handbook now, because we are updating, but just looking at some, we have the nice to haves and the needed to have, right? Oh, how you might handle accommodations, either religious or disability accommodations, you might want to consider putting in there. Rules of conduct, general rules around conduct, what you expect. So again, this is about expectations in the workplace.
Would you also put in there, April, expectations for volunteers?
Ooh, this is a tough one. So what I would say is we don't have a handbook for volunteers, but we give volunteers, we do have some language as part of our registration process that sets the tone. So when people sign up, we're like, this is what you should expect. Not only, wear closed-toed shoes, but how we like to work with each other. And then also we have a volunteer orientation where we speak to not only what are you doing today, but a little bit about our culture. So we don't have a handbook, but we try to inform. That's a great question. Let's see, we don't have a lot of time. Oh, employment of relatives or close relations. Whether you allow for a husband and wife or for dating in the workplace and what that means. You might want to be clear that if someone starts dating their subordinate, what you want to do about that, and to communicate what that is. Anything about safety, if there's anything in particular, you want to make sure that if people always have to wear closed-toed shoes in a particular area, no smoking in a particular area or on your property, things like that.
Social media.
So,
policy.
yep, I was just gonna say, we have a couple of things. We have a non-solicitation and non-distribution policy, which basically speaks to, you can't put up anything posted in the building without the organization's permission. You can't distribute. Now, this gets a little sticky, especially in smaller organizations, because it's like, well, every year somebody wants to buy Girl Scout cookies. So what that means is if you have personal relationships outside or have the personal email addresses of someone, feel free, go ahead. Just don't use GBFB property to do so, emails, etc. Don't post anything up. We also have a social media use, personal blog and or social networking policy, and a mobile device use policy, basically saying that mobile devices, whether it's your personal or a company paid, if you use the device for company business, then that device in part becomes, now we're much larger and there's reasons why we put that in, but in part the company can request access to your what is your personal device because you're using that for business. And this is especially important when it comes to using the texting feature. Sometimes employers have gotten into trouble based on texting that happened on personal phones that people were using for business reasons. Any information about time off that I talked about, benefits. So those are sort of the main things. Again, our handbook is several pages long and we have a lot in our appendix, but we're also, I don't think I said, fully staffed, we'd be about 150 people. So that speaks to the complexities of some of the employment things that we have to deal with. So our handbook accordingly is long. So hopefully that helps.
There's a question about where to locate sample handbooks. I can just say, by the way, there are sample handbooks out there with not-for-profit organizations. Be very careful about simply adopting a sample handbook because it may not be applicable in Massachusetts. It's not bad to look at, but be careful on adopting things wholesale. And I think if you Google, there are organizations of not-for-profit. If you Google sample not-for-profit handbook, I'm sure you'll come up with some of them.
Yeah, and there are some resources, I'm gonna forget the name of the organization that you may be able to, if I remember, then I'll send it to Dominique to send out. Admittedly, since we're in nonprofit and food banking, I'm always sharing our handbook with other food banks. There's nothing in there that it's definitely our handbook, but I'm always happy to share. You may not want it because it's a lot, but there's nothing sort of, we give it to other organizations all the time to just, the only thing I would ask is that you don't share, at least without me knowing, but it's, again, I'm happy to send you the PDF, but fair warning, it is, we're at a lot of pages. Like with the appendix, it's over. With the appendix, it's 120 pages. I know, Mark.
You don't need.
You do not need 120 pages.
No.
The handbook itself is about 50. It's just the appendix that we choose to include some things. So.
And the ZACM Funds employee handbook is a lot shorter. We're in the process of revising, and I would have to ask the board whether that's something we can share, but it may be if people want to take a look at it.
Olga, are we required to provide a handbook hard copy to employees or electronic also count? You can do either, but what you should do is have a mechanism for capturing that they received it. So you want an acknowledgement that they received it and an acknowledgement that they are expected to abide by what is contained therein. So if you send it electronically, then you can either ask them to sign something, like I would suggest there be a form and then they can sign it and send it back to you. Or in these days, you can give them the language and ask them to reply to that. These are best practices that I've experienced, not by law or anything. You can ask them, you can give them the language and say, when you please respond, acknowledging the following, and then have them repeat what they're acknowledging in the things. You can do that, but you really, whether you're required to or not, I do advise you strongly considering getting acknowledgement of those two pieces.
One thought I had, and this goes back to the topic of employee versus independent contractor. Just because you put in your handbook that the person's an independent contractor doesn't make him an independent contractor. There's a specific, I mean, every independent contractor case, the person has signed a contract saying I'm an independent contractor. It has no legal effect. So the tests are whether you meet the 3-part standard that's in the law that I gave you. So again, even if someone acknowledges something in a handbook, if it's contrary to law, it has no effect.
That's definitely true. That's definitely true.
Okay, we're just about out of time. Any other? Okay, Dominique put in the chat, one of the things that you get is Lenny Zakim Fund grantees is access to pro bono legal services. So one thing I can urge you, if you have questions, ask before you do it. I mean, the most common things that lawyers will tell you is they get a call from their client saying, oh, this is what I did. Was there any problem with it? And you say, yeah, it's about a $300,000 problem, where it would have been, even if you had to pay for legal services, it would have been a $500 cost to get advice. You guys can get advice for free. So to the extent that you have any questions, please ask. It's much better to avoid the problem than to try and deal with it after it's hit the fan. So with that, I thank everybody for your participation. April, it's been an absolute pleasure doing it with you. Again, please feel free to contact us if you have questions, if issues come up. We're here to help you.
It was a pleasure, Mark, as well, and nice to meet and talk with you all.
Great. Thank you, Dominique.
Thank you, Dominique.
Yeah.
Have a good afternoon, everyone.
Thank you all.
Take care, everyone.
Thank you.
Thank you so much.